The honourable member for Vancouver Kingsway.
Thank you, Mr. Speaker. On October 7th, 2011, the Minister of National Defence introduced Bill C-15, an act to amend the National Defence Act and to make consequential amendments to other acts. Bill C-15 amends the National Defence Act to strengthen and alter military justice following the 2003 report of the former Chief Justice of the Supreme Court, the Right Honourable Antonio Lemaire, and the May 2009 report of the Standing Senate Committee on Legal and Constitutional Affairs. Among other things, Mr. Speaker, the bill provides greater flexibility in the sentencing process. It provides for additional sentencing options, including absolute discharges, intermittent sentences, and restitution. It modifies the composition of a court-martial panel according to the rank of the accused person. It modifies the limitation period applicable to summary trials, and it allows an accused person to waive the limitation periods. This bill clarifies the responsibilities of the Canadian Forces Provost Marshal, and finally it makes amendments to the delegation of the Chief of the Defence Staff's powers as the final authority in the grievance process. Mr. Speaker, the New Democrats believe that Bill C-15 is a step in the right direction to bring the military justice system more in line with the civilian justice system. However, it falls short on key issues when it comes to reforming a number of required aspects of the military justice system, including the summary trial system, the grievance system, and the Military Complaints Commission. Some background, Mr. Speaker. In 2003, the Right Honourable Antonio Lemaire, former Chief Justice of the Supreme Court of Canada, presented his report to the Independent Review of the National Defence Act. The Lemaire report contained 88 recommendations pertaining to military justice, the Military Police Complaints Commission, the grievance process, and the Provost Marshal. Bill C-15 is the legislative response to these recommendations, but thus far only 28 of those recommendations have been implemented in legislation, regulations, or via changes in practice. This bill, Mr. Speaker, has appeared in earlier forms. First, Bill C-7 and C-45 died on the order paper due to prorogation by the Conservative government in 2007 and an election in 2008. In July 2008, Bill C-60 came into force, simplifying the structure of the court-martial system and establishing a method for choosing the type of court-martial more closely aligned with the civilian system. In 2009, the Senate Committee considered C-60 and provided 9 recommendations for amendments to the National Defence Act. In 2010, Bill C-41 was introduced to respond to the 2003 Lemaire report and the Senate Committee report. It outlined provisions related to military justice, such as sentencing reform, military judges and committees, summary trials, court-martial panels, the Provost Marshal, and limited provisions related to the Grievance and Military Police Complaints Commission. Process. Mr. Speaker, in essence, Bill C-15 is similar to the version of Bill C-41 that came out of committee in the previous Parliament, and there's a number of amendments that carry over, which include the court-martial composition and military judges' security of tenure and provisions related to the appointment process and age of the judges. However, other important amendments, Mr. Speaker, passed at committee stage at the end of the last parliamentary session are not included in Bill C-15. And these include the following, which were also presented by the New Democrats as amendments to that piece of legislation. What's missing from this bill is the authority of the Chief of Defence Staff in the grievance process, responding directly to Justice Lemaire's recommendation. What's further missing are changes to the composition of the Grievance Committee to include a 60% civilian membership, and finally a provision ensuring that a person who is convicted for an offence during a summary trial is not unfairly subjected to a criminal record. And it's this last point, I think, that causes particular concern to all Canadians who care about the justice system in this country. Mr. Speaker, there are many important reforms in this bill, and the NDP supports the long overdue update to the military justice system. Members of the Canadian Forces are held to an extremely high standard of discipline, and they, in turn, deserve a judicial system that is held to a comparable standard. The NDP will be opposing this bill at second reading. However, there are shortcomings in this bill that we hope can be addressed at the committee stage if it does in fact get that far. Here's some of those amendments that we hope to see passed. The amendments in Bill C-15 do not adequately address the unfairness of summary trials. Currently, a conviction of a service offence from a summary trial in the Canadian Forces may result in a criminal record. Summary trials, though, are held without the ability of the accused to consult counsel. There are no appeals or transcripts of the so-called trial, and the judge is the accused person's commanding officer. This causes an undue harshness on certain members of the Canadian Forces who can be and are, in fact, convicted of very minor service offences, offences that would not otherwise be criminal offences. For example, some of these minor service offences include insubordination, quarrels, disturbances, absence without leave, drunkenness, and disobeying a lawful command. Now, these could be matters that are extremely important and are important to military discipline, but they are not necessarily worthy of a criminal record. Certainly, drunkenness is not a criminal record or a criminal offence, and many members of this House would probably attest to that. Bill C-15 also makes an exemption for a select number of offences if they carry a minor punishment which is defined in the Act or a fine less than $500 to no longer result in a criminal record. And this is one of the positive aspects of the bill, but it does not, in our opinion, go far enough. At committee stage last March, the NDP amendments to Bill C-41 were carried to expand this list of offences that could be considered minor and not necessarily worthy of a criminal record. We would increase that number from 5 specified offences to 27, and if the offence in question received a minor punishment. The amendment also extended the list of punishments that may be imposed by a tribunal without an offender incurring a criminal record, such as a severe reprimand, a reprimand on its own, a fine equal up to 1 month basic pay, or another minor punishment. This was a major step forward for summary trials. However, this amendment was not retained in Bill C-15, and we want to see it included here. Mr. Speaker, we also believe it's important to reform the grievance system because at present the Grievance Committee does not provide a means of external review. Currently, it is staffed entirely of retired Canadian Forces officers, some only relatively recently retired. If the Canadian Forces Grievance Board is to be perceived as an external and independent oversight civilian body, as it was designed to be, then the appointment process needs to be amended to reflect that reality. Thus, some members of the board should be drawn from civil society. The NDP amendment provides that at least 60% of the Grievance Committee members must never have been an officer or non-commissioned member in the Canadian Forces. Again, this amendment was passed in March 2011 in C-41, but was not retained in this bill before the House, and we think it's important to see that amendment retained in this bill. Finally, the NDP believes we must strengthen the Military Police Complaints Commission. This bill amends the National Defence Act to establish a timeline within which the Canadian Forces Provost Marshal will be required to resolve conduct complaints, as well as to protect complainants from being penalized for submitting a complaint in good faith. Although a step forward, the NDP believes that more needs to be done to empower this commission. Care has not been taken to provide the Military Police Complaints Commission with the required legislative provisions empowering it to act as an oversight body. This commission must be empowered by a legislative provision that will allow it to rightfully investigate and report to Parliament. Now, Mr. Speaker, let's talk about what some independent people have said about this bill. I want to quote Colonel Michel Drapeau, a retired colonel from the Canadian Forces and military law expert. Here's what he said in February 2011, quote, "I strongly believe that the issue of summary trials must be addressed because there is currently nothing more important than for Parliament to focus on fixing a broken system that affects the legal rights of a significant number of Canadian citizens every year." Why? Because unless and until you, the legislator, address this issue, it is almost impossible for the court to address any challenge since no appeal of a summary trial verdict or sentence is permitted. Also, it is almost impossible for any other form of legal challenge to take place since there are no trial transcripts and no right to counsel at summary trial. Colonel Drapeau also said, "I find it odd that those who put their lives at risk to protect the rights of Canadians are themselves deprived of some of these charter rights when facing summary trial. If Britain, Australia, New Zealand and Ireland have seen fit to change the summary trial process, it begs the question, why is Canada lagging behind?" End quote. Mr. Speaker, I believe all members of this House want to see that members of the Canadian Forces are guaranteed the very charter rights that we send them into harm's way to fight on our behalf. And part of those rights are when you face a potential criminal sanction, you have a right to counsel. You have a right to a judge that's independent. You have a right to transcripts and a meaningful right to appeal. Bill C-15 does not allow this, Mr. Speaker, and I urge all members of the House to work on this bill to address those serious problems.